Mr. Vaughn, can you tell me what case you're here on?
Yes, Your Honor. I'm here on Ferris v. Funding LLC, assignee of Millennium Falcon Group versus Thoy Tran and Bank of America as the garnishee.
1 minute.
Yes, Your Honor.
Mr. Ting, are you there? Mr. Ting, are you there?
Yes, Your Honor.
All right, can everybody hear me?
Yes, Your Honor.
Yes, Your
All right.
Honor.
We're on the record in 22 CCV 0778 Ferris Funding LLC, assignee of Millennium Financial Group LLC versus Thoy Tran versus Bank of America NA garnishee. Let me get announcements from the attorneys. We're going to start with Mr. Ting.
Yes, Your Honor. John Ting for Ms. Thoy Tran.
Mr. Moeller.
Good morning, Your Honor. Evan Moeller for Garnishee, Bank of America, NA.
Mr. Vaughn.
Morning, Your Honor. Jimmy Vaughn here on behalf of Plaintiff Ferris Funding LLC, assignee of Millennium Financial Group LLC.
Hold on, we just lost my court reporter. Dang it. All right, hold on 1 second. Let's get her back on. Gentlemen, hold on 1 second. Let me find out. She's logging back on right now.
And Your Honor, I just spoke with my client, so she should be joining soon. Just had to walk her through the Zoom.
She's not in the waiting room.
Okay, I'm going to message her again. I apologize, Your Honor. I'm just going to give her a call real quick to help her.
I apologize. The computer's acting really slow.
Are you fully connected now, Stephanie?
Yes, sir.
Okay. What was the last thing you heard?
You just called the case.
Oh, you stopped it. Okay, well, let's go through
Yes.
announcements again. All right. Mr. Tang, I'm gonna need you to get off the phone.
I apologize, Your Honor. I was trying to walk her through the app.
All right, we're back on the record in 22 CCV 071488 Ferris Funding LLC, assignee of Millennium Financial Group LLC versus Tutran versus Bank of America NA. Now we need to go through announcements again because my court reporter didn't get anything down, basically. So, Mr. Ting, we'll start with you.
Thank you, Your Honor. John Ting for Thuy Tran.
Mr. Muller.
Morning, Your Honor. Evan Moeller for Garnishe Bank of America, NA.
Morning, Your Honor. Jimmy Vaughn on behalf of Ferris Funding LLC, assignee of Millennium Financial Group LLC.
Millennium. I like that. Okay. All right. We're here on a motion to dissolve garnishment. And there's a order for motion to set aside, but I don't have a motion to set aside. I just have the motion to dissolve garnishment. All right. Mr. Ting, these are your motions. And if I will tell you this, Mr. Ting, if I see your client come in to the waiting room, I will pull her in to the hearing immediately, or my court coordinator, Ms. Sarah Toller, will pull her in. She has rights to do so. So
Okay.
if she shows
Thank
up,
you.
we'll pull her in. Okay.
Sure. Thank you.
See.
Just, yes, Your Honor, we have a motion to dissolve the garnishment. She has completed the property interest claim form, which contains the check marks as to what the wages in that bank account, I believe, is Bank of America. And further, when I checked the records for the previous case I gave, it was not from what it appeared, the service was not complete from the first case, the prior matter. Let's see. So therefore, we're asking that, Your Honor, we're asking for that order to dissolve the garnishment. I apologize about the proposed order. I e-filed the wrong one.
Who would like to respond first?
Your Honor, Jimmy Vaughn on behalf of Ferris Funding. The first thing I'd like to point out to the court is that any defect in a garnishment has to be pointed out by a sworn affidavit. We don't have a sworn affidavit from Ms. Tran. We have a sworn affidavit from her attorney, but there are some defects in that in regarding it saying that these facts are within Mr. Ting's knowledge. And it says that the judgment was rendered on October 20th, 2022. I asked the court to take judicial notice of its own record, which evidences that the order granting the garnishment was entered on 12/19/2022, not October. So that calls into question the credibility of the affidavit underlying this reading. Furthermore, it's unsworn. Rule 664A of the garnishment's rules of civil procedure require the court's determination to be made on the basis of sworn statements. Otherwise, evidence must be entered, and no evidence has been tendered. Secondly, regarding the service in the prior suit, Your Honor, that's a collateral attack. Any defect in the underlying judgment that supports the garnishment prior to the garnishment judgment must be attacked by a bill of review. Ms. Tran has not filed a bill of review. We are unaware of any such bill of review in this action, and those statements cannot support setting aside the judgment. Furthermore, Your Honor, lastly, we have not received a notice of protected property rights being filed in this case. Even if they were filed, Your Honor, income, once it reaches a party's bank account, becomes intermingled with the other funds, garnishing income and the protection thereon under the United States and Texas Constitution only protects it from the employer to the employee, not once it reaches the employee's bank account. So anything that was contained in that bank account, the moment it got commingled with the other funds, it lost its identifiable and traceable characteristics and were subject to garnishment by Ferris Funding under the order. It's for these reasons, Your Honor, we ask that the court deny the motion to set aside the default judgment.
Mueller.
Thank you, Your Honor, if I may. From a disinterested stakeholder's perspective, obviously, we have no interest in the outcome of the dispute between the judgment debtor and the judgment creditor. However, the elephant in the room presented by the procedural posture in which we sit now is duplicative liability. A judgment was already rendered, and we essentially have a post-judgment intervention, which is not permitted by Texas law. So if Your Honor were to enter an order dissolving the writ at this point, effectively ordering us to return the funds, we will have paid twice, which is a situation that a garnishee should not be put in. If there are attacks upon either the underlying judgment or the garnishment judgment, there are proper procedural mechanisms to bring those. A post-judgment intervention in the garnishment proceeding is not the appropriate vehicle. So we would ask that the court take notice of our concerns and deny the motion to dissolve.
Mr. Ting, your response.
Yes, Your Honor. I've in terms of the date of judgment, I was referring to, I believe I'm looking at a timeline here. It's October 9th, 2007. And from our stand, it has to be 10 years that the order to do the garnishment, to renew the garnishment, has to be within 10 years of that judgment date. And I didn't represent Ms. Tran that first case. So I'm just looking back at the Fort Bend County records, and it appears to be October 9th, 2007. And Mr. Vaughn mentioned that the recent garnishment or judgment was December 2022. But it sounds like from the other attorneys that this is not the proper mechanism to get it set aside, essentially.
Your Honor, may I respond to the
Oh, hold on.
timeline?
Mr. Ting, are you complete? Are you done with your response?
I'm complete right now. Thank
All
you,
right,
Your Honor.
go ahead, Mr. Vaughn.
Apologize, Your Honor. I'm a little eager. Had too much coffee this morning.
Since you were representing Millennium Falcon as well, too. so-
Yeah, exactly. Yeah, the moment that came out of my mouth, I had visions of Star Wars, and I was like, "That's not the right word." Your Honor, regarding the timeline, judgment is revived by writ of garnishment. The garnishment doesn't have to be issued within 10 years. A party just merely has to file the garnishment within 10 years. This was filed well before the 10-year time frame had been entered. So it would effectively revive the judgment even if there had not been a garnishment. But as Mr. Mueller had pointed out, and as I mentioned previously, this is a lateral attack on an underlying judgment that's already been handled. If it was a motion to set aside, that would be totally different, but this is styled as a motion to dissolve the writ of garnishment, which has already been garnished.
Mr. Ting, anything further?
Thank you. Thank you, Mr. Vaughn and Your Honor. I'm scrolling down a timeline. I think the most proper date, I think Mr. Vaughn is referring to, and you correct me if I'm wrong, please. I see February 13th, 2017. I see a request for writ. And and just tracing back. Is that the date you're referring to, Mr. Vaughn?
No, so that date does revive it, Your Honor. So that's a writ of execution. And a writ of execution, the only thing that has to happen is more than mere clerical preparation, and it has to be delivered to the constable or to the party that's going to be serving the writ of execution. And according to the court's record, that was done. So it revived the judgment beyond the 10-year period. Even if that hadn't occurred, Your Honor, this garnishment was issued within the applicable statutory.
Okay. Mr. Ting, there are other avenues for you to deal with this situation. This was not the proper avenue. I'm denying your motion to dissolve at this time.
Thank you,
All
Your
right.
Honor.
Anything else for the record? Mr. Ting,
Nothing further. Thank you.
Mr. Vaughn,
Millennium Falcon out.
Mr. Moeller.
No, Your Honor.
All right, y'all have a good day.
Thank you.
Thank you, Your Honor.
Thank you.
Freshwater,
How you doing, Your Honor?
I'm good. I don't see opposing counsel in this case. I show that you sent notice.
Yeah, he got notice and he even told me he was probably just going to dismiss it, but I don't know, maybe he just lost track of the hearing.
Well, I've reviewed your motion. It's proper under the circumstances. Let's do this. Let's get on the record. We're on the record in 22 CCV 072080, Mohammed Afzal versus Rainbow Business LLC. Mr. Freshwater, let me get your announcement for the record.
David Freshwater here for Rainbow Business LLC.
I'd like the record to reflect that plaintiff's counsel Javier Martinez for Mohammed Afzal is not present for the hearing. The court has reviewed defendant's plea to the jurisdiction and is granting it at this time. Anything else, Mr. Freshwater?
No, Your Honor, may I be dismissed?
Yes, you may. Have a good one.
Thank you very much.
All right, that concludes this morning's civil motions docket. Thank you all.
Thank you.